Welcome to the Military Justice Today podcast with your host, Robert Capovilla and Mickey Williams, covering the full range of military law topics from all branches of the armed forces. Today's episode is made possible in part by the law firm of Capovilla and Williams. And now, let's welcome the hosts of the show, Rob and Mickey.
All right, everybody. Welcome to another episode of Military Justice Today. I have with me today Robert Capovilla and Mickey Williams, military defense attorneys, friends, overall good guys. Hey, thanks for joining us. We've got a really good episode today on court-martials, or courts-martial, I guess is the proper way to say that, Robert, isn't it? Courts-martial?
I believe it's courts-martial.
There you go. We've got a great episode today. We're going to cover it in depth. We're going to try to get through as much information as we can over about 45 minutes. But how about a quick pre-show question? And your question today, and it could get deep, is what advice would you give to your young self?
Oh, goodness.
See it, and it's totally a shocking one. No, I didn't give you any. I didn't give you any
Facebook.
advance notice about this. But
oh yeah, lots of financial advice.
Yeah. What is the advice you would give to your young self? And it could be any advice at any age, to be utilized in any way possible to make you a better human being. All right, I've stalled enough for you. Here you go, Cap. Think on your feet. What do you think?
So I'm tempted to pick something financial. Mickey had already mentioned it. I'm tempted to say invest in Facebook, invest in TikTok, because you'd be worth quite a bit of money if you did that right now. But aside from financial things, I would tell my young self to spend more time with my dad, and to spend more time with my grandparents. I lost both my dad and my grandparents in a very short period of time, close together. And kind of that whole side of the family just disappeared overnight. And now as a grown man, I look back at that, and when we have holidays coming after the holiday season here, I think back about how much fun it was being around a bunch of Italians, drinking, eating, watching football. This past weekend, I was at the Ohio State-Georgia game. I'm a big Buckeye fan. I was with my dad's best friend. I thought about my dad a lot. So I think that my advice to my younger self was spend more time with your old man and maybe go a little bit easier on him.
That's great advice. I think we could all learn quite a bit from that, at least the second part of that advice about going easier on them, because it's not an easy job. Mickey, what about you? The advice you would give to a young Mickey Williams?
I would focus more on patience, I think. I think I have a tendency to, when an issue comes up, whether it's a financial issue or it's a relationship issue, whatever it might be, I think that patience is probably the better course of action instead of reacting right away. Sometimes, even if I miss a turn and I'm driving somewhere, I'll get really upset. Like, why the hell did I miss that? Oh my God.
Yeah.
Because I was daydreaming or whatever. There was a term that I learned early in my career, was like, there are no legal emergencies. And I think that's true in life generally. There are no real emergencies. Like, you can get through things if you just, it shall pass, this shall pass too, kind of deal. I would talk about, I would say, hey, not everything is end of the world scenario for you. And then also, I agree with Rob about spending time with family if you can. They're only here for a short while, and they are a portal to the past. There are certain things, experiences that they've witnessed that you can only maybe read about in books, but how things really were, to me, is fascinating. I think we're only 2 generations away from the turn of the 20th century, or from the 1900s, or not from the 1800s to the 1900s. I guess that'd be the turn of the 19th century into the 20th, and that was a completely different world from what we're living in now, and I'd be fascinated to know what it was like to live in those times.
And the only way you get that is from those people in your family that can pass those stories down,
right?
Unless you're famous and there's people writing about you, which
my
grandma, we don't have that issue.
My grandmother was born in the 1930s, which means her mom was born in like the 1800s.
Yeah,
right. And my great-grandma's grandma was probably born in the 1860s or 1870s or something. I mean, that's just wild to think about. So my great-grandmother would have known at least secondhand what it was like to grow up during the Wild West, which is one of my favorite pieces of American history. So, it's things like that.
I think fostering those relationships is probably on almost everybody's list. Whether it's somebody they lost or just somebody they didn't connect with as well as they probably could have when they were younger. But, it's everybody wants to foster more relationships or better relationships than they did, I think, when they're older. So,
yeah. It did get heavy, Matt. How dare you?
Matt.
Look,
Jeez, man, how dare you?
I thought it was going to be like I would lift more. I would.
Now I'm sitting here thinking about my dad. Like, oh man, I miss my dad.
I would probably say, hey, don't hit it so hard because I got so many issues now with my back and everything else.
I know. I thought you guys were going to be like, I would have done an extra set every week. And
yeah. I mean, try to.
There'd be a couple girls that I would tell young Rob, you're best off just to walk the other way, brother.
Yeah,
trust me on this one.
That's right. Yeah. All right. Well, let's jump into our topic because it's one that probably could go a span of 4 or 5 shows, and we're going to try to push through it in this 45 minute episode. But it's the court-martial process, and I think we want to cover kind of the nuts and bolts of it, what the different phases are. We're going to cover some of the terminology. We're going to cover some of the do's and don'ts if you're facing one, what you should be doing or should not be doing. And you guys, I'm sure, will share some stories about some of the more interesting things you've seen going through it with clients.
Yeah, and the reason that I wanted to do this episode, Matt, was because a lot of times when we talk to people who call into the law firm, both folks who are accused of crimes and also family, right? Parents. One of the first things they always ask is, what is this process? What can we expect? And my hope is that for this episode, we stay away from the legal technical side of things and talk a little bit more about just generally what that father, that mother, that grandmother, that client needs to understand about this process. Because if you're not part of it, if it's not something you work, it is a mystery to you, and it can be confusing. And certainly if you're charged with a crime, the only way to describe it would be terrifying.
Yes. Well, there's no question about that. And there's no way for somebody to know this about this until they go through it. So, well, that's great. Well, I guess why don't we start with the obvious question, which is, what is a court-martial? Mickey, you want to go?
Sure. It's a federal trial. It's simple as that. I mean, so what I'll say too is, this is not a small matter. A court-martial is just as significant, if not more, than a state trial or federal trial, what have you. It is. You can go to jail for the rest of your life. You can get the death penalty. All the same penalties that you're facing on the civilian side can happen on the military side. So a court-martial is essentially a trial that's held within the United States military. And it encompasses all the same steps, right? From investigation to pretrial matters to trial, post-trial, the appellate process. It's all there.
What are some of the most common charges that you would face a court-martial for?
In today's day and age?
Yeah, we're talking about serious things, right? We're not talking about
domestic violence, sexual assault, negligent homicide, murder.
BAH fraud.
BAH fraud, AWOL, that's another one. Drugs.
Yep.
I mean, that's typically what you see. Sexual assault, I think that's the vast majority of them.
Yeah.
Quite honestly. And that's just because of where we are as a society and what these guys are bringing to trial. But you'll see everything. I mean, I had a case one time where bestiality was on the charge sheet, believe it or not.
Really?
Yeah, really. And
I remember that case.
Kind of crazy.
Yeah. Disobedience before the enemy, that's another, or misbehavior before the enemy, that's one, right? Like you've got some weird military specific crimes, but then you've got your run of the mill stuff.
Yeah.
And then anything that's not codified, they can create under Article 134.
Really?
Yeah, they can pretty much create a charge if there's something that they think should be bad, but it for some reason isn't codified by the UCMJ. They can create it as long as it hasn't been preempted by some other statute within the code. So,
Rob, how does a court-martial start? What's the beginning of the process? I'm assuming somebody makes an accusation or something happens and then a service member is given notice. But how does it actually happen?
Well, let's take the sex assault example because that's the vast majority, I think, of general court martials that are going forward. There's an allegation of a crime. Right? Alleged victim goes in to law enforcement or to command or whatever, makes a complaint. At that point, a series of events starts. You're going to likely, you being the accused, you'll likely be flagged. Even if it's the weakest allegation of all time, you're going to be flagged. You're likely going to be removed from your position, suspended from duties. And then OSI, CID, NCIS, we'll throw CJIS in there. They're going to go out and conduct an investigation on you, to conduct an investigation whether or not there is credible evidence to support the allegation. They're going to interview your accuser. That's usually recorded. They're going to interview all the people your accuser says they should interview. They're going to go collect evidence, text messages, phone records, whatever they can find to corroborate the allegation. Eventually, law enforcement's going to want to talk to you, the accused, and that's going to be a big decision for you, whether you make a statement or not. I strongly recommend that you hire counsel for that. But that's kind of how everything starts. It starts with an allegation, and that will lead to your military file is flagged. They will not be able to take any favorable action towards you. So if you've got PCS orders to Hawaii, those are likely going away. If you've got orders to go to a service school like Air Assault or Ranger School, whatever, you're likely not going. Even if it's the weakest allegation in the history of mankind, you're not going. And then a law enforcement investigation is going to kick off.
All right, so 2 questions. First to you, Rob, about confinement, and then to you, Mickey, on what somebody should do if they're facing this initially. So, Rob, confinement, is somebody always put in jail when they're charged with something like this, or not necessarily?
No, not necessarily. In fact, the overwhelming majority of cases that we have that do end up at general court martial, or where the individual is charged with a crime that could go to general court martial, they're not placed in confinement. And in the military, we call that pretrial confinement. And there are a series of steps that have to take place if the military is going to place you in pretrial confinement. They've got to get a 48-hour memorandum and a 72-hour memorandum, typically from your commander, saying, hey, you're a flight risk. It's likely you're going to commit serious misconduct or have committed serious misconduct. And if you're placed in pretrial confinement, which does happen, typically speaking, you're going to have the right to a hearing in front of a hearing officer within 7 days. And then if that doesn't go your way and the hearing officer says, no, you're staying in pretrial confinement, you can now challenge that before the military judge prior to or before referral. But to answer your question, no, pretrial confinement, unless you're in the Marine Corps, where they throw everybody in pretrial confinement for everything, pretrial confinement is relatively rare.
Yeah, I had a guy get thrown in pretrial confinement because he said a bad word. Believe it or not, yeah.
Marine Corps loves pretrial confinement.
All right, Mickey, well, we talked about being flagged, being removed from your job. We talked about pretrial confinement. I guess the obvious answer is the first thing you should do is get an attorney. But what's the first thing somebody who's going through this should be doing to protect themselves?
Not talk. I think that's the biggest thing. You're inside, and you're inside jail. The people will want to talk to you. Well, those people can turn to snitches really fast. And in fact, that's why they're asking you questions, because if you spill the beans to them, they can get a better deal if they flip on you. So that's the first thing. Don't talk about anything. Only talk to your attorney. Don't talk on the phone to your parents about it. Just tell them, give me a lawyer, have them give me a call, because the lawyer will be able to talk to you and have a confidential conversation. Whereas if you're on there, you're talking to your mom, dad, I didn't do this, or I did do it, but it was a mistake, or whatever. Those are statements that can be used against you. So,
and they're recorded.
Yeah, they're recorded. And that's the first thing. And keep calm, right? This stuff will work itself out. It will happen. And the one good thing, if there is a good thing about pretrial confinement, is this. First off, you're not going to get in more trouble, okay? Because you're in pretrial confinement. And secondly, every day that you're in there counts towards your sentence if you were to get one.
Yeah.
Right? The goal is to get you acquitted. But let's say you were to be convicted, then those days count towards your sentence.
Rob, is there any point in this process where it's too early to get an attorney?
No. And in fact, we've been doing this long enough to say hiring an attorney, whether it's our firm or somebody else, right? Hiring an attorney as early in the process as you can is vitally important. Number one, it gives you a voice. Number two, we have the ability to Capovilla Williams to conduct our own investigation. CID is not likely going to interview the folks you tell them to interview. We will. We've had every single year we have multiple allegations that get dropped because we go out and collect our own evidence. We don't like relying on CID or OSI or whoever. And then also, you've got to be protected. When you're accused of sexual assault or any other serious allegation that goes to a court-martial, one wrong thing you say one wrong thing. You do an interview with CID or OSI or whoever, and you think that they've got your best interest and they're buddies with you, and you say one wrong thing, guess what? You might find yourself getting prosecuted and convicted. Those people are professionally trained interrogators. They know all the evidence. They've interviewed all the witnesses. They know what your accuser's saying. You know nothing. Zero. So you have to fight the impulse to clear your name. You need to hire an attorney, and you need to be patient. Because you're not going to do yourself any good by going out and making a statement 90% of the time.
Or trying to investigate things yourself, right?
Don't do that.
Contact the accuser.
You know what will happen? They'll charge you with obstruction, right? Or interfering with the investigation. The other thing, too, is they're allowed to lie to you while you're in there. But if you say anything that they misinterpret or misunderstand what you said, they can charge you with an additional crime, which is a false official statement. So you got to be very careful.
Let me share just a quick story, okay, about the nature of these things. I represented a 19-year-old kid like myself from Ohio. He was stationed at Jack's Naval Station. He had been accused of sexual assault. Very, very good-natured guy. Came from a really, really, really nice family. He goes in to talk to NCIS in his own kind of way. And he's going to clear his name because he knows in his heart he did nothing wrong. It wasn't even possible to him that NCIS could recommend prosecution or whatever because the case to him was so clear. He was in the hotel room with her. They had hooked up. He had no question about what he did. And in that interview, he denied everything. Of course, he was shocked. Of course, I didn't do that. I would never do that. No, she's lying. That didn't happen. She was never asleep. Then they tell him, well, what if we tell you that she recorded what happened in that room and it captures you assaulting her? Literally.
Yeah.
And he goes, oh my God, oh my God, oh my God. Maybe I was drunker than I thought. Oh my God, oh my God. Maybe I was too drunk. Oh my God. Guess what?
They never had a recording.
No, the recording never existed. And guess what? The prosecutors started their opening statement off with, oh my God, I was drunker than I thought.
Yeah.
Ask yourself, is that justice? Because I can tell you on cross-examination, when I finally got to look that agent in the eye, it was very clear to the panel what happened wasn't justice.
Yeah.
And that's what you're facing. So don't try to fix the problem yourself. Get help.
Yeah, it's not a problem you can fix without the knowledge and skill and experience of an attorney.
Correct. If you want to make a statement, if it's very important to you to clear your name as soon as possible, fine. Get a lawyer.
Yeah. Understood. Okay. Well, let's move on to the next phase. Is that preferral of charges? What's the next phase of this thing?
Preferral of charges. Mickey, you want to talk a little about what preferral means and all that sort of good stuff?
Yeah, what preferral means is that the government believes that there's probable cause that a crime occurred. And if they want to take it to a general court-martial, which is the highest level court-martial around, it's basically a superior court for the military, they have to send it to an Article 32 hearing. So preferral is just basically, hey, it's not a formal indictment because it hasn't come back from the Article 32 or it hasn't gone to a grand jury as a true bill is what they would call it on the state side. But they've basically said, yep, you're charged with this crime and we want to move forward with it.
So they've decided through their investigation, as good or as bad as that investigation could have been, that there's something here and we're going to move forward with this case.
Yeah.
And then that turns into an Article 32 hearing?
Yeah, so investigation happens. The investigation can take anywhere from 3 months to a year, right? Mm-hmm. Depending on the allegations. The government recommends to the command that there's enough evidence to move forward with a court-martial, and preferral means you're officially charged, like Mickey said. Now, what that means in practicality for you is if you're the one being charged, you will be told to go to your commander's office, likely your company level commander, right? Your 03, maybe 04 level commander. And that commander will notify you of the charges. They will read them to you. And then they will ask you if you have any questions. You should say no. Even if you do, you don't ask your company commander, who's the accuser in the case, questions. At that point, you should be given the charge sheet. and you have your initial discovery rights. You get to see what evidence the Preferral, the Preferral authority, right, reviewed in deciding to prefer the case. You get to see any statements that are in the possession of the government. Essentially, your first discovery rights kick in. So you're going to finally find out what people are saying, and then that takes us to the Article 32 hearing. So that's a little bit of a rough shot over what Preferral is.
Yeah. So I think the answer to this question is going to be obvious, but what is the emotional toll on somebody who's reached this point of the process? I mean, you talk to a lot of folks that are going through this. You do it every day. What is their mindset? Are they in shock that this could be happening? What is the mindset of a person that's now facing this and it's moved to this stage?
Usually by this point, the accused, our client, and the family is exhausted. Because remember, they've now been under investigation for 3 months, 4 months, 5 months, 6 months, a year. They've not been able to promote. They've not been able to go to service schools. They might not be able to take leave. And they've been under the stress of this investigation all that time. They're likely doing a job that they shouldn't even be doing anymore because they were suspended from their own duties. So sometimes the most common feeling from my perspective with Preferral is almost a sense of clarity and relief, believe it or not, because now they understand there's no more confusion. The government is coming after them. So there is a sense of like, okay, at least I know now what's happening, but it's an exhausting experience. And if you think about it, that person may be found not guilty, charges may be dropped, but they're never going to be able to get their career back on the same trajectory it was 6 months or a year earlier. It's just very difficult to do. The damage in some ways is already done.
Yeah. Yeah. So what's next? The Preferral, Article 32, now what?
So Mick, you want to talk a little about the Article 32 process just so that folks understand, what that is?
Yeah, that's no problem. So the 32 is the probable cause hearing. And the purpose of it is to give an independent, I guess, fact finder is what I would call them, the opportunity to review what the government believes happened and whether or not, one, the court even has jurisdiction over the case, right? Because that's important. Whether the charges are in the proper form because they can change the charges or recommend, hey, you didn't charge this correctly. Whether there was a crime that has been alleged and whether or not the accused is alleged to have committed it and whether there's evidence to support that by the standard, which is probable cause, right? That's all that's needed. And then I think that covers all of that. I think,
and it's conducted by who? Is there one hearing officer? Are there multiple?
So there's just one hearing officer. In the Army and the Navy, you're typically going to deal with an 03 or 04 level judge advocate. Who is going to essentially act as the preliminary hearing officer. In the Air Force, they do an interesting thing where if it's a serious case or a sex assault case, they like bringing in military judges,
which is great. That's what you want.
I love it.
Because what I have found and what Rob, I think, will concur with is that if there's a kangaroo court, it's going to be this.
Absolutely.
Because you have very limited rights as an accused in a situation like this. It used to be, well, back with probably, I think they changed it in 2014,
right?
Something like that. It used to be that these hearings were actual hearings where you could call witnesses and present evidence. Now they've limited it to the scope and purpose of the hearing, and it's a very narrow understanding or very narrow view of what's allowed. So you can request discovery, you can request witnesses, but the government can object. And ultimately, it's up to the preliminary hearing officer, the Article 32 officer, whether or not it is relevant. And 9 times out of 10, they're going to say it's not relevant. I don't even care. It's outside the scope. Right. And what I mean by kangaroo is even if you get a favorable ruling or a favorable report, because they compile a report from the preliminary hearing officer saying this case should not go to trial, right? You will lose this case, government. It should not go to trial, or there's not enough evidence. I don't think it meets probable cause. They can still take it to trial, and they do.
They almost always do. So your 32 officer.
What's the point of having that?
I don't know.
And that's why one of the serious conversations, one of the first real serious conversations you have with your client about the court-martial process is it even worth litigating the Article 32, or will the potential pitfalls outweigh the benefits of going to the Article 32. Because you also have to remember, this is really important for folks, that 32 officer can also recommend additional charges. So if your attorney goes through the evidence and finds additional misconduct, that 32 officer can recommend that it be charged. And in the Marine Corps in particularly, they love putting those questions in front of the court, in front of the 32 officer on purpose. They will actually present evidence of uncharged misconduct, hoping the 32 officer recommends prosecution on it. And that's why a lot of times in this day and age, we waive, unless there's a specific tactical reason to have the 32, we request that our clients waive those 32s because the benefits are so small and the potential for additional charges is there. And we know even if we win the Article 32, the SJ is not going to care. The SJ is going to go to the convening authority and still say, in my opinion, it ought to go forward. And who's the convening authority going to listen to? Their legal advisor or some 03, 04 judge advocate who he's likely never met before?
Yeah.
Yeah, and one last thing about that, there's a strategic aspect to it as well. If you know that they've charged the case incorrectly and that you can get that charge dismissed either at referral or at the 917, which is typically done after the government's presented their case, you wouldn't want to do a 32 and give the IO an opportunity or the FOD an opportunity to recommend changing the charge.
Yeah.
In order to help the government, you see.
You also don't want to give them your theory of the case 6 months before trial because, trust me, they will find a way to fix it.
Yeah. Yeah. That's interesting. So when you guys first said Article 32 and you have kind of this independent person, which doesn't sound all that independent, but at first I started to think that maybe this was the first time that the defendant was getting somebody on their side, but it sounds like it's really just the opposite.
It's become
There's
almost
very little good that can come out of that.
It's become almost a paper pushing activity, the Article 32s. It's not every time, but 99% of the time it's almost pointless to have them. I wouldn't say 99% of the time. 90% of the time it's pointless to have them.
How long do they usually last if there is one?
35 minutes to an hour, not very long.
Oh, it's very short.
Yeah.
Well, it depends.
From the defense side, certainly, because you're not putting on very much. You might be attacking. For instance, if you know there's no evidence. I had a case just recently, and I had a good result at the 32, where I said this doesn't qualify. What the misconduct that they're alleging doesn't. It had to do with a false official statement. So a lot of people think that if you lie to the cops, like I just said earlier, you're going to get, that's a false official statement. That's true if it's a military police officer.
Yeah.
But if it's a civilian police officer, unless there's a military connection to it, it's not a false official statement.
So you were able to get it dismissed right then and there?
I was able to get it recommended to be dismissed. They could still go forward with it because I think the whole reason for charging it was in order to make other things relevant, because you can only bring in evidence that's relevant, right?
Yeah.
That's like the first hurdle. Is it relevant? Well, if it's charged, then anything surrounding it becomes relevant. So whether they actually, maybe I'm giving them too much credit for thinking this way. If it's not charged, then they can't bring in this other stuff. But if it is charged, then they can't.
Yeah.
Right. So they might still go forward with it despite that.
Okay. What's next? You have Article 32 hearing and then
referral. And I don't think we need to spend a ton of time on referral. What the person being accused of a crime needs to understand is referral means that a court martial has been convened by the commanding general, and that the case is now being sent to the military judge. And that's really all you need to know about referral, besides the fact that you have a number of rights as an accused that kick in at referral. You have your full discovery rights under the RCM 700 series, the right to production, right? The right to production of evidence and statements and all those different things that matter for discovery. Your attorney, you do have subpoena rights. You can request the government produce evidence, the 32 and things like that. But really, once referral happens is when that full scope of the accused right to discovery kick in. It's when the accused, in large part, his constitutional rights kick in. But it basically means at this point, the case is now going to be assigned to a military judge.
What would you say is the average time from when somebody is flagged until this referral happens? And I'm sure it varies widely depending on the nature of the charges and the evidence.
No, from being flagged, meaning just the beginning of the investigation, to referral, probably 6 to 8 months.
Oh, yeah.
A long time.
I'd say from preferral to referral, because they only have 120 days. Once they prefer against you, they have 120 days to get that case referred. That's it. That's all they got. 4 months. Seems like a long time, but it goes by quickly because in between that time, you've got the Article 32, the report, and it's got to go up through the chain. And so it takes some time. So and if, from flag to referral, yeah, I mean, you're probably looking at a year at least.
Yeah, which I would assume is an incredibly stressful time for that defendant and their family. What are the things that a good defense lawyer is doing during that 6 to 8 months or whatever it is? I mean, we've talked about some of it.
Well, yeah. I mean, it depends on where you're at in the process, right? If it's the eve of the Article 32, a good defense attorney is preparing an argument for why this should not move forward. But by and large, after preferral is when we like to conduct our initial review of all of the evidence. So we're going to review the entire report of investigation as long as we have it, the evidence against our client. We're going to want to interview those witnesses at preferral, a lot of them, right? You're going to want to interview eyewitnesses, people who know things, to try to start identifying inconsistencies or holes in the accuser's story. You're going to want to identify what experts you need in the case. If it is referred, you're going to want to start thinking about what discovery you need to request. You're going to want to start thinking about theme and theory of your case. So that time from your preferred to referred is a wonderful time for a good defense lawyer to really get elbows deep into the evidence and start developing your theory of the case. Because the longer the time passes, the more likely it is the prosecutors are going to start interviewing witnesses and things can get kind of funky. That preferral to referral time is a vital time when it comes to preparing a case.
And your investigators are working throughout that process to uncover what they can uncover.
Yes. At once preferral happens, most of the time the people interviewing the witnesses are going to be the attorneys assigned to the case. Pre-preferral, we use investigators to go out and find people and talk to them. But once you're preferred, the attorneys need to start, really digging in deep and figuring out what's what, because you never know. You never know what a witness interview is going to reveal. And I've told attorneys this, I've told clients this. The law enforcement report only captures 50% of what actually happened. You're never going to know what really happened until you start interviewing witnesses yourself. Do not ever rely on CID or NCIS or whoever's version of what the witness said. You'll be shocked at how many great things you'll get by doing interviews early.
Yeah, and it's funny because they'll say that their investigation is accurate, but then they'll turn around and say, well, it's just a summary.
Yeah, right.
Right. So,
right. I didn't feel a need to include the fact that she sent him nude photographs. It wasn't something that I felt was relevant at the time.
Yeah. Okay, so I obviously we're moving more toward what I think is going to end up being a trial in this process, but is there anything in between the two? Are there hearings? Are there things that you're battling the prosecutors on before the trial starts?
There are a few things. And I just ran into this issue, basically subpoenas. So defense attorneys in the military do not have subpoena power to get certain evidence. And if it's perishable evidence like text messages or Facebook messages, whatever, electronic media that you need, and that if you don't preserve it, that it could be gone forever. The first thing you do is you send a preservation request to the other side and say, hey, I want you to preserve this evidence. And then they're supposed to make a good faith effort to try to preserve it. Then the next thing is to file a request for a subpoena or a warrant to capture the evidence that you're seeking that they haven't done. And then they are required to do it either themselves or go to the military judge to get it. And I think this all falls under Article 30Alpha as well, if I'm not mistaken. The same thing as the pretrial confinement stuff, because you can do this at any time. You can do this during the pre-preferral stage. So during the time that you're flagged forward, you can do this stuff.
Yeah.
Right. But a lot of times you're stuck with whatever the trial counsel is willing to do, and you can't get it in front of a judge until after the Article 32, because you can request that the foe do the same thing. So
what I'm hearing is complicated filings to obtain information, preserve evidence, all of that stuff that you're going to then need in trial, I'm assuming.
And the next big kind of moment in the trial after referral is the Article 39A, which is the motions hearing, right? That's going to be, we skipped over arraignment, which we shouldn't have done.
There's some big rights that attach at arraignment.
So after referral, you're going to have arraignment, and that's going to happen usually, within about a week or 10 days. And that's going to be the accused's first appearance in front of the military judge. the prosecutor will be there. This is the one hearing we typically as civilians don't travel for because there's no real litigation 99% of the time. And you're going to be notified of the charges against you. You're going to be notified of your rights to counsel, your rights to certain kind of forums. You're going to put your first, a lot of times, the judge is going to ask about pleas in form. That typically is deferred at the arraignment. The whole thing lasts about 7 or 8 minutes, and there's really nothing besides, you acknowledging a few things on the record that you need to be worried about. There's no litigation that goes on at the arraignment, typically speaking. Once arraignment is done, okay, the next major step in the court-martial process is the Article 39 Alpha, which is your motions hearing. And that's the first litigious, your first time your attorneys will litigate in front of the military judge. You will be there with your defense counsel. The prosecutors will be there. The military judge will be there. And you'll have legal pleadings that you submit to the court, that your attorneys will submit to the court for issues they want to address outside the presence of the panel. So, for example, if you said something to the police or law enforcement, but law enforcement potentially violated your rights, you're going to want to file a motion to try to get a charge dismissed. Military Rule of Evidence 412, the rape shield law. There's certain, if you're wanting to admit into evidence that your accuser sent you nude photos, the morning of the alleged assault, you're likely going to have to file that motion to try to admit that evidence. So that's an opportunity to address legal issues outside the presence of the panel. And then what'll happen is you'll hear argument, you may hear witnesses called, evidence presented, and then the judge will make a ruling on that evidence, on those petitions or pleadings, for lack of a better term.
Is it safe to say, or fair to say, that this is when a really good defense attorney starts to shine, that really starts to
I think a good defense
on behalf of that defendant in a way that's different from the prior stages? I
wouldn't necessarily agree with that, because great defense starts day one. Getting to the evidence, interviewing witnesses, a thorough investigation is key. That is, in my opinion, one of the biggest moments in the entire court-martial process. You got to know what you're playing. You got to know what you've got, right? You got to understand the evidence against you. That's the first time where having a good lawyer in court makes a big difference, right? Because that's the first time you're going to be litigating legal issues. So having experienced counsel at the motions hearing, that's the first time you'll be truly, truly, truly grateful that you have somebody on your side who knows what they're doing.
Yeah. Yeah. Motions hearing, it's very important because it shapes how trial is going to unfold in a lot of ways. And it gives you kind of a roadmap of what you're allowed to do and what you're not allowed to do. And that helps you with your openings and your crosses. So that right there, motions are key. If you fail motions or you don't file a motion that you should have, you might be in some hot water. Or your client will be, which isn't good. One thing I want to say about arraignment, I don't think was touched on, was the reason I want my guys arraigned as soon as possible. ASAP, get them arraigned. And that's because the government can't bring additional charges. So if they miss something that they forgot to charge, that they want to now charge, they can't. It's not in that court martial. They can go through the whole process again and try to bring a second one.
It's not like you can amend the charges easily after that point.
No, not at that point. And in fact, they can't even change, after arraignment, they can't change the charges. They can't make, quote, what's called a major change, which could be the difference between an acquittal and a conviction, believe it or not.
Can you get these charges dismissed at all these phases that we've talked about at this point? Are there times when the prosecution, as things develop, they say
all the time
we can't, or is it really like once they've dug their heels in, they're going?
So the charge sheet is it's the judge's charge sheet after arraignment. It's his or her charge sheet. So the government can't do anything to it, but you can file motions for failure to state an offense or lack of jurisdiction anytime you want. Typically, the judge will give the government all the time in the world to try to fix whatever the issue might be, because that's just what they do sometimes. But yeah, you can file it any time. If they don't have jurisdiction, that's an easy one. Yeah. You know what I mean?
Well, it can be easy. It can also be quite difficult.
Well, I mean, if there is no jurisdiction, it's clear that there's no way. If it happened before he joined the military, then yeah, that's going away. There's no jurisdiction.
I once heard from somebody else that a lawyer once said, "Judge, it's not my job to fix the prosecution's case." Has that ever happened?
Oh, sure.
Yeah.
Yeah.
Oh, sure.
Because sometimes when you're making an objection to foundation, the judge will be like, "Well, what about the foundation? Don't you like it?" Like, Your Honor,
yeah,
you either think there's a foundation or not. I'm not going to tell the government what they need to do.
That's right. That's not your job.
Yeah. Here's my objection.
Those very words have come out of my mouth in a court martial.
Well, I thought I heard it from somebody else. But. All right, well, let's talk about the trial real quick, and then we'll wrap up. We've talked a lot about trials, actually, because we've done separate episodes on opening, close, witness cross-examination. But let's just talk generally about the trial. I think what most listeners would want to know is, how do these things unfold? How do they go? Who's the jury comprised of? What are kind of the nuts and bolts of the trial, without getting too deep into strategy and that kind of stuff?
Yeah, that's no problem. So after referral, after the motions hearing, there's a trial date that's set at arraignment. We're going to go trial in the state. There are some deadlines before that. You got to get your voir dire questions in. You got to get witness lists in, and so the judge can prepare his questions for the voir dire for the jury. The jury is picked on day one of the trial, but the actual panel, the pool of the jury pool, is picked by the commanding general, the convening authority. They're the ones who pick the pool on who we get to decide who the jury is from.
Really?
Yeah. So they pick, 15. The government, out of those folks, will assign 15 people to go for voir dire, and we got to get it down to 8, right? Because 8 people comprise the court martial. And then you pick your jury. It goes through this process where it's randomized, and then finally you have your jury. They're picked, and then the next day, and the first thing that happens in the morning, if there's no issues to take up before court begins, sometimes there's evidentiary issues or something that came up that needs to be litigated over the night. It happens from time to time. Then you go into opening statements.
Yeah, and then the trial proceeds.
Trial kicks off.
As we see in the movies.
Just like it.
And on TV.
Openings, government puts on their case, we cross their witnesses, and if the defense has a case, sometimes you don't. Sometimes you don't want a case. Or you don't need a case because your case is just attacking their case. But if you have witnesses that you want to call, then the defense puts on evidence. Then the government gets an opportunity to rebut any evidence that we put on, and sometimes they do, other times they don't. And then you get an opportunity to rebut that as well, and it goes back and forth as many times as
Do you have a good idea when you walk into a trial how long it's going to go?
Yeah.
Who's going to be taking the stand, what the issues are going to be? I mean, do you know that going in?
I have a pretty good idea. I can estimate it. I'm pretty good at that. But if it's Air Force.
Yeah. If it's an Air Force trial, just plan on a month.
Yeah.
Okay, plan on a month. And you better know your case law. No, I'm kidding. Air Force trials do tend to be rather longer than the other branches.
Even the judge alone ones.
Yeah.
If you go judge alone, you're going to be there 5 days.
Yeah.
Yep. Yep. But no, I mean, it's the trial process is the part of the court-martial process that popular society is most familiar with, because the trial process is not really any different than your typical trial process anywhere else. Voir dire, openings, government's case, defense's case, rebuttal, surrebuttal, closing, sentencing, if you get there. That part of it is pretty standard across the board. It's the part that gets you to trial that confuses folks and that seems so foreign, because how the military does it is different. I hate the fact that the convening authority gets to pick and select the jurors. I think that is something that should change, and change fast, much like unanimous verdicts. I mean, if they tip the scale any further in front of the government, it'd be pointless to even have these trials. That's sometimes how I feel. And it's amazing that there aren't more convictions, but there aren't, because the cases aren't very strong, and by and large, service members go out and get good counsel. But it's very similar to what you see in popular culture, the trial process.
Yeah. And I guess, I know I keep coming back to this, but I always think about, if I were in the shoes of a defendant who's going through this. But what are the conversations like that you're having with that person and their family? Are you giving them kind of your best estimation of how things are going to go, what the worst case scenario is, what the best case scenario is, what you've seen happen in the past? Maybe if you're familiar with the judge, are you having those conversations with that person and maybe even their family members, or is it more we're getting down to business doing what we know we need to do to win?
Go ahead, Rob.
No, I was just going to say all of the above. Okay. We owe it to the client in particular. And if he or she elects to have us speak to the parents, we owe it to the parents as well to be very, very honest about what we see and what we think. That starts in the second you're hired. I don't know how you could look yourself in the eye as a defense lawyer if you're bolstering things to stay on a case or make some money. Our core value, which we're going to have a podcast on, number one is respect your client. And in there is honesty. So yeah, I typically will explain the things that we expect to go right, the things that we expect to go wrong. And I always make sure that my clients are emotionally ready for the fact that they could end up in jail, because that's on the table anytime you go into trial. There is no such thing as a slam dunk at trial. What those 8 people think about the case is a mystery to everybody in the courtroom till the verdict comes out. So yeah, I mean, I know everybody at my firm strives to be as honest as we can about the potential outcomes, the strength of the evidence, the good points and the bad.
Yeah, I agree with Rob. At the end of the day, when the judge is recessed for the day and we've got a time to be there the next day, I'll take 10, 15 minutes afterwards to kind of go over my thoughts about how it's going, where we're at. During the actual trial, when I'm have to sit there and listen, I can't be getting peppered with questions from my client at that time, because I got to pay attention. So during a break, we'll talk about it. But yeah, you've got to do that, and you got to manage expectations. If the case isn't going well, the client already knows it, right? But he's looking to you to kind of convince him otherwise. But you got to be honest with the guy. Hey,
sure,
this is what this is bad, or this is good, right? Here's where I think the case is going. But ultimately, you have no idea.
Yeah,
you don't really know.
What advice would you give to family members who are trying to support their son or daughter going through this process? Maybe it's the advice anybody would give, but what can they do or not do to help their loved one go through it?
That's a hard question. I think just support, emotional support, because their loved one is going to be going through the most difficult time of their lives, which is something that I think SJAs and trial counsel forget about, that these are individual people with families, that they're not just names, they're human beings with a heartbeat. And parents and family support, unconditional support, really, I don't know how else to answer that question. Help them find the right attorneys. Don't be afraid to spend some money to get the right person, because once that conviction happens, they live with that consequence the remainder of their lives.
Yeah. Yep. All right. Last couple items. Sentencing, appeals. Probably not too much to talk about in that respect, but at the conclusion of the trial, a verdict comes down, right? As we all know it does. And then
it happens quick. You do closing, you get some instructions, you go out, the panel deliberates, the bailiff comes gets you. They say it's time. There's all this energy that has been spent. Everybody's tired. We're hopeful. We're not hopeful, whatever. And you go in, and within a matter of seconds or minutes, really, will the accused and defense counsel please rise? You're standing there with your client. Your heart is in your throat. The client is probably not even able to breathe. The family is nervous and scared. The alleged victim and her family are there. The courthouse is packed, and the judge reads the verdict. And when it's a not guilty, it's quick. It's like, of the charges and their specifications, we find the accused not. And as soon as you hear, like, oh, thank God, thank you, Lord. I always pray when it happens. I'll hold my client's hand sometimes. I've seen clients break down and cry. I've seen them, all kinds of reactions. And then sometimes it's, we find the client guilty of X, Y, or Z. And that is additionally taxing. That is additionally heartbreaking, especially if it's something you didn't expect.
Yeah. Mickey, anything to add on that?
You can kind of tell. You can kind of tell how the jury's going to go when they walk out.
And how long they deliberate too, right?
Yeah, that's an indication. I can't read too much into that, because I've had cases where they deliberated for 2 days and they came back full acquittal. When they come out and they look at you and they're looking at your client, that's a good sign.
Yes.
If they are looking at you but they're looking away real quick, or they won't look at you, that's not a good sign.
Or if somebody was on your side and they look really upset, not a good sign.
Yeah.
And then also,
all that before?
Yeah. And also, before the judge reads the verdict, he goes through this, he analyzes the findings. There's a findings worksheet, and he highlights certain portions. If he highlights one line, that's either full acquittal or full conviction. So if you got the eye contact plus one highlight, that's good.
Yeah.
If he's sitting, he's highlighting one thing, highlighting a couple other things, that means it's mixed findings.
But as Rob said, this all happens in seconds. for a minute.
It happens quick. I don't even look anymore. I don't even look. I just stand up and just, kind of pray, and I don't even really look, because you could get yourself all spun up on different things, which of course we all still do, right? Mickey and I talk every single time when we're waiting for a verdict. What do you think about that? What do you think about this? What do you think about that?
Yeah.
Oh, I think the panel member farted. What do you think that means? Oh, I don't know. Something you said upset their stomach. Oh my God. Oh geez.
Yeah, we try to read the tea leaves. Like Rob will be like, hey, the judge just asked me a really interesting question and I've got concerns about it. And I'm like, yeah, that's a weird question, man. I've never had that. And ultimately didn't mean anything.
Yeah.
But
I mean, I've had cases where I'm confident the whole time it's going my way. And then the judge will say one thing and I'll be like, oh man. And I won't sleep that night. I won't sleep. That's the nature of the beast that you're in.
And I think, I would never want to lose sight of the fact of what's at stake for your client, because obviously that's first and foremost on your mind. But these little nuances keep the work interesting for you guys. I mean, it's interesting work as a lawyer and somebody who operates within this environment, right?
I don't know if I would use the word interesting. I think I would use the word intense, exhausting at times. It's a process unlike any other. You are in the arena, you're with your client, you're bleeding and sweating with them, and everything's at stake. So I wouldn't call it interesting. I would call it, I'm at a loss for words. I would call it the most intense experiences I've had in my life.
yeah, it's just really stressful. And I used to wear a heart monitor. I don't wear it anymore because it was just depressing to me. Anyway, I would have a normal heartbeat, and then during trial, it would shoot up. Like I said, I ran a marathon or something at the end of the day. Like I ran 10, 15 miles, and that's how it feels. It feels at the end of the day like you just ran all freaking day, and then that accumulates over days. And then the hardest part for me after a trial, whether you win or lose, doesn't matter. You can't get to sleep. You can't
unwind your mind.
Yeah,
No,
for
you
days.
can't. You can't.
For days. It's like 3-4 days before you have a good night's sleep after the trial is over, because you've had so much adrenaline pumping through your veins that it just takes a while for that stuff to calm down.
There's been many occasions where trial wraps up at 4, 5, 6 o'clock, and I'll have a 7 or 8 hour drive home, and I'll just I'll just go home, throw all my stuff in my pickup truck, and drive as far as I can get, because whether you win or you lose, there's just this instinct of you can't quite slow down yet. It's still with you, and driving has always been a way for me to clear my brain. So that's something that I do. That's why I don't like to fly as much, because you're stuck there. Good or bad, you're stuck there. It is a real feeling. I mean, it is a real feeling. It's why why we talk about with our attorneys, you are in the arena as a trial lawyer. We don't take, we're not wills and estates guys. You know what I mean? We're not reviewing documents for a living. We are in trial with big moments, and it takes a certain kind of person to do it, and to do it well. And I love the pressure. I've always enjoyed the actual trial itself, but the preparation and everything, there's not been a time in recent memory where I haven't, at the conclusion of a trial, I'm out for 3 days.
Yeah.
I'm out. My brain's shot, my body's shot. I'm going to go spend some time with the family and not think about the law, because it takes a lot out of you.
It does.
Well, and I think that's actually a good point to be made for those that are hiring you. This is taxing on you. I mean, and it's not inexpensive to hire a good lawyer. Everybody knows that. But this is what you're getting. You're getting X amount of hours or days out of somebody's life, and even after that trial's over, that person you've hired is still, trying to turn it off, and it's hard to do.
We talk about that from a business perspective, right? That you can't, I don't know how some other civilians are doing 20 trials a year. We don't do that because we don't think we can be at our best. And the people who hire us deserve us at our very best, period. And the day that I walk into a courtroom without butterflies in my stomach is the day I should retire from doing it, because if you're doing it right, you're going to feel it every time. Whether you think your client in your heart is innocent or not, you're going to feel it every single time if you're doing it right.
Yeah. Well, it was a great episode, guys. I think we could probably wrap it up here. I know we could talk more about each one of those phases. We could talk about some post-trial stuff, but I think we did a good job of covering the specifics. I think we talked quite a bit about what the client's going through and what they should be doing throughout the process as well. So another great episode. Tune in next time. Until then, Matt Starosiak with Robert Capovilla and Mickey Williams, Military Justice Today podcast. Take care, everybody. Be safe.
Thanks for listening to the Military Justice Today podcast with your hosts, Robert Capovilla and Mickey Williams. This show was made possible in part by the law firm of Capovilla and Williams. For more information or to listen to more episodes, visit militaryjusticetoday.com.